Hi, my name is Diana Chavez. Thank you for joining our webinar. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today, we have a great webinar on getting paid faster with liens, bonds, and contracts by the amazing construction attorney, Leslie Baugh. Without further ado, I would like to introduce Leslie Baugh.
Thank you, Diana. I'm happy to be here today to talk to you about this important topic. I'm an attorney licensed in Kansas and Missouri, and I've been practicing construction law my whole career. So these things are staples of every day of my practice as a construction lawyer. As we proceed, if you have any questions, I just switched slides here so you can see the instructions. If you have questions, please use the chat box on the right, and we'll go through the questions at the end of the webinar. When you do post your questions, don't include your name or company name, just ask your question and we'll get to that at the end. So to get started, I was reflecting on the title of this webinar and how these are really tools to help you get paid. And they're valuable every day in securing your right to get paid. But today I'm going to try to focus on how we can use these tools to get you paid faster. I also was reflecting on the fact I should have called this contracts, liens, and bonds, because it really all starts with your contract. And I'm going to start our conversation today about your contracts and then move into the lien and bond aspect of those. So while the title of the webinar is Getting Paid Faster, I just do want to take a moment and note the difference between getting paid faster versus getting paid fast. So I can just sort of set expectations here because everybody would love to get paid fast. We don't have a lot of control over all of the factors that get factored into how fast you're going to get paid. What we're going to talk about here today are tools to help you get paid faster than you might have otherwise gotten paid had you not utilized your tools. And this is important because there's a wide variety of reasons why payment might be slow in coming on a construction project. So we all know that the typical payment process on a construction project is that each supplier and vendor is going to submit their pay application, whatever form that may take, an invoice or a formal AIA type certificate and payment application. Those get submitted up the contractual chain, and depending on where you are as a lower tiered sub or supplier, it may have to go through a few steps before it's actually in the owner's hands, where then they have some time to look it over and approve payment. And then once they disperse payment, it has to travel back down through that same chain. So what we often see are concerns about the lower tiered subs and suppliers as to how long this can take. And so one of the things that we want to go through here are best practices that you can follow so that there's no basis to withhold your payment. We want to make it easy for people to pay you. And a key idea that I'm going to reiterate several times throughout this morning's webinar is don't wait. If you're getting a sense that payment is going to be slow or it is actually already coming slow, you want to start to implement some of these practices. Don't wait until you've got a lot of money into a job and you're a few months down the road and you've got a really big balance sitting in your accounts receivable. Just be really diligent about jumping on these things, which means communicating within your company and having some red flags set up so that people with accounts receivable are aware of what's going on the project, so you have some communication between them and your field personnel. You know, the old, on that last slide about don't wait, the old adage that the squeaky wheel gets the grease is so true in the construction industry. So if money's tight for any reason for any contractor and they've got people bugging them, those are the people that are going to get paid first. It's just the way it is. So don't wait and be noisy. And like I indicated in the beginning, all of how you're going to proceed with this really starts with your contract. So it's very important to negotiate and understand your contract. So there are other webinars that I presented earlier this year that you can view on SunRay's website that will cover the contractual provisions that are key to getting paid in a lot more detail. Today, I'm really going to hit on ones that we want to highlight as very important in the effort to get paid faster. So obviously, in your contract, there's going to be some provisions about what you're going to do to get paid. And in a more complex, robust contract, it's going to be more detailed in what you have to provide with your payment application. So number one, make sure that everybody who's participating in that process understands what the contract says. What I see sometimes is that companies just have their own practices of what they typically submit, and then they may get a payment application sent back because they didn't include some paperwork that was required. And then you might be looking at your payment application doesn't get submitted until the next month. So you want to, again, make it easy for them to pay you. Provide everything that needs to be provided along with your payment application, and understand what your contract requires in that regard. And the next contract clause that I think can impact your ability to get paid faster are your dispute resolution clauses. Now, a lot of people don't think about these coming into play until later, in terms of, we got to get this project done and then we'll fight about what we're getting paid. But in your contract, you'd like to have some provisions of how you will make decisions on disputes that take place during the course of the project. So ones that I like to see are requirements that the parties, decision makers, will directly negotiate. It's nice to have a process in place where you submit to an initial decision maker, like the architect, and for a requirement that the parties mediate prior to arbitration or filing suit. So if the parties are comfortable with mediation, that can come into play. That can be really useful in a lot of ways, because you may be able to resolve disputes without the expense of litigation. But in the effort to get paid faster, if there's a problem while the project is ongoing, you can reserve your right to get paid on those claims and mediate them very quickly, and try to get the payment process rolling. Secondly, I always like to advise my clients to take notice of all the notice requirements within the contract. So we go into great detail in notice requirements with regard to just protecting your right to get paid, period. If there's changes in the scope of work, if there's delays on the project, there's probably going to be notice provisions about how much notice you have to give and when that should be given in order to preserve your right to get paid for those changes if they're compensable. But also keep in mind that the sooner you give notice of extra costs, the sooner the ball gets rolling all the way up that contractual chain to obtain extra funds for those changes from the top. So while it's important to preserve your right to get paid on those claims, it's also really important in order to get paid faster. And a real important part of that is being on top of it in terms of what are the costs associated with the change or with the delay. And I've had many, I don't know how many times we've had clients say, we're going to have a claim. We can't put numbers on it right now. That doesn't mean you wait to give notice. Put them on notice of anything you know. That way, there's no dispute about whether or not you gave notice. And if you're providing information and being real transparent, like I said, we just want the process of getting compensation for that to be started as soon as possible to get the money in your hands as quick as possible. There's all kinds of nuances that go along with that in terms of, nobody's just going to be writing blank checks. So you're going to have to document those things, and we'll talk about that in a few minutes here. But as far as your contract goes, a real key provision is knowing when you can suspend your work. Suspending work on a project is a real big decision. Obviously, doing so will hold up the project. You want to make sure you've got all of your ducks in a row. I always advise you talk to counsel before doing so. But there will be provisions within your contract that you can put people on notice of your intention to suspend work if payment is not forthcoming. And those can be really useful to get somebody's attention, light a fire, and get you paid. So next up, we'll look at what some of those clauses can look like. I've just pulled a payment provision from the AIA contract, the short form between owner and contractor. Just be aware there's similar clauses in the lower tiered subcontract. So the form contract for the contractor and subcontractor will have something similar. This is the certificates for payment clause, and I just want to bring your attention to the last sentence, starting 3 or 4 lines up. And this is dealing with once you've submitted appropriate application for payment. This contract had a consultant who would review that. Sometimes it's an architect, and submit it to the owner. And we see here that the provision states, if certification or notification is not made within such 7-day period, the contractor may, upon 7 additional days written notice to the owner and consultant, stop the work until payment of the amount due has been received. So real key is understanding those timelines. So there's deadlines for how long they have to pay you once they've gotten a payment application, and then you have to wait you have to provide notice for an additional 7 days before you could actually stop work. So that's where your conversations really need to be taking place with counsel. Obviously, a lot of times we have issues with disputes about the work. But putting in formal writing notice of your intention to suspend work if payment is not forthcoming will get someone's attention, will bring a lot of attention to what's going on, and hopefully you can negotiate how you will proceed with work and preserve the right to be paid for whatever work is in dispute. You could potentially engage in an informal mediation very quickly. But these are the kind of provisions that you can put into play to help you get paid faster. Because notice provisions will, I'd like to put everybody on notice. So put as many people on notice as you can, not just what's required in the contract. So you can get everyone's attention to your plight and the fact that you aren't getting paid. Next up, I pulled a similar clause from the consensus docs format, and you'll see that it has the same 7-day, and these are all negotiable, but these are just the standard forms. So the 7-day notice requirement, and it actually includes a provision that if they call it the constructor instead of the contractor, incurs costs or is delayed resulting from the shutdown, then you can seek an equitable adjustment in the contract price or the contract time. So these are provisions that appear in standard contracts that will very clearly define your ability to suspend work. One thing I want to touch on is if you're dealing with a contract that does not include these types of provisions, you need to obviously, again, consult with counsel, but I would pay very close attention to the payment provisions. What we're seeing more and more today is inclusions of clauses that say you have no right to get paid if the contractor or above you has not yet been paid. So we call that a pay if paid. And what we prefer to see is a pay when paid clause. Pay when paid clause does give you a right to suspend work because courts have interpreted that here in Missouri to mean payment should be coming in a reasonable amount of time. So again, pay if paid clauses and pay when paid clauses are a topic for a whole separate webinar of their own probably. So I'm not going to go into too much detail there, but want you to be aware of your rights to suspend work under those 2 different types of payment clauses in your contracts. And I harp on this in probably every webinar I do, whether we're talking about liens or bonds or delay claims or anything, but documentation really is key to getting paid, and it's key to getting paid faster. Clear and easy to understand claims get paid faster than ones that have to be submitted to some sort of forensic accountant to make any sense of them. It's very important for everyone to note that documentation needs to be contemporaneous to be valuable. So for someone to go back at the end of a project and try to reconstruct what was happening based on their texts and their emails is not as reliable, and courts don't look at it as reliable evidence as, let's say, a daily record that's maintained daily. And this used to be a bigger battle, I feel like, than it has been today, because back in the days when we had everybody out there with a clipboard taking notes by hand and then trying to put those together into some kind of a report. We're all carrying around little computers in our hands now. So there really isn't any kind of an excuse for failing to document what's going on a project contemporaneously. Next up, it's really best if you have a standardized procedure company-wide with consistent internal practices and forms for your staff to use. This helps with gaps in documentation. So if you have one superintendent that always, documents all the details about the weather and how many people are out there and what other subcontractors were out there, then you have somebody who's not. The question is, well, if this is your practice, this guy's not reporting it. If it's not made note of, maybe it's not important. So we really want everybody to be utilizing the same practices and documenting the same information so that nobody can read into the fact that no note was made about the weather that day, so it must not have been an issue. Good documentation will help establish the cause of events, whether it's a delay or if we've got conditions on the project that were unanticipated. It helps preserve your rights. If you could document that this was mentioned at a meeting and that this is the response you got. It will also help identify the actual costs and delays. So if we're trying to go back, like I mentioned earlier, and put together a claim for a delay claim, this kind of documentation is what will help you put actual numbers on your claim and help you identify the actual costs and what impact it had on your productivity and that kind of thing. So what I also like to stress is, while we're carrying around these little computers in our pockets, it is very beneficial because it makes it easier for people to document what's going on the project. But I also like to stress with people that we still want to observe some formalities with regard to our documentation. So what I've seen is the easier it is to communicate, the more casual people tend to be in their communication. And unfortunately, when there's a dispute on a project, this can result in, a text battle back and forth with profanity and whatnot as emotions get involved. So what I always like to coach everybody who's managing a project and working on a project and communicating and preparing this documentation to do is think twice before you hit send, whether it's a text or an email. And if it's not something that you would type up and put on a formal letterhead with your company name on it, don't send it. While we want documentation, we want good documentation. And the old adage that, anything could end up being an exhibit in court if you wouldn't want it being read aloud for a judge and jury to hear, let's not put it in writing. So key to documentation is do it, but do it well. And that leads us right into, what are we going to use this documentation for? We've already covered a few situations where we might need the documentation, whether it's documenting changes in work or scope of work or contract price or delay claims. But also, if you actually don't get paid, in order to prove up at the end of the day a good lien claim or a bond claim, you're going to need the documentation to support your claim. So documentation will be key for proving up and making your lien and bond claim, but it will also be key in helping those get decided sooner. So if I'm an owner's attorney and I get a copy of a lien filed by a supplier or a subcontractor, or a copy of a bond claim that's been made, and all of the documentation is in order, all of the documentation is very clear, there's nothing in there to really dispute, that's going to lead to a quicker decision on how we're going to handle that claim than if there's gaps and it's not clear, and if there's any questions about the validity of the claim. The other thing I'd like to say with regard to both liens and bonds is don't wait. We'll talk a little bit in the next slides about time limits that come, but just because you may have, in Missouri, we've got 6 months to file a lien, but just because you have 6 months, don't wait 5.5 months to file it. If you're not getting paid, start the process immediately. If you're a subcontractor and you have to give a notice of your intention to file a lien, get that out there right away as soon as you can. Put everyone you can on notice of your situation. Some people do not get a copy, let's say, of a title report that with all of the interested parties in a real estate, like the mortgage holders and whatnot, until it's time to file a lawsuit. Depending on my client's decision about how to proceed and what kind of cost they want, or what kind of how much they want to pay to pursue the claim, we may order that right away. That way we can put banks, everybody who's interested in the property on notice that there's going to be a lien filed, and that may get everyone's attention. So don't wait till the last minute. Be the squeaky wheel. As far as bonds go, so so back up a little bit. We've got lien webinars, we've got bond webinars, and those will go into much more detail about how you make a lien claim, all the notice provisions you need to file, what you need to do to make a bond claim. And I'm just hitting the highlights here so that we can have a conversation about why these things might be helpful in getting you paid faster. So just know that there's a lot more to filing a lien and a bond than what we're covering here, and go back and watch the other webinars. I think we all understand that we can file a lien on a private project. If we're on a public project, then we're dealing with bonds. More and more on large private projects, contractors may be, or owners may be requiring contractors to obtain payment bonds. So it doesn't hurt to ask for a copy of any bond covering a project, even if it's private. But if you're on a public project, that's going to be your only way to proceed. So you'll want to get a copy of the payment bond ASAP. I like to recommend people get those right off the bat when they're starting work. That way you've got it in your file. We can go look at it when we need to. And, because there could be issues of, do we want to get everybody's ruffling feathers because we're asking for a copy of a bond right now, once we're getting hints that payment may not be forthcoming. If you don't have it straight up, that's fine, because asking for a copy of the bond is one way to bring attention to the fact that you aren't getting paid. So I like to have it as quick as we can so we know what you have to do to make a bond claim. You want to review time deadlines within the bond as well as within the statutes. Notices for a sub or lower tiered subs and suppliers are going to be really important. And then you have to follow all the requirements in making the bond claims. It's going to tell you who to send the notice to. It's going to tell you what you need to submit. So follow all the requirements of the bond. Both of them, I like to get everybody on board with what are your deadlines, for the project where you're located, before you even start work. This is important for everybody within your organization to understand, because like we've talked about a little bit, is you need the people on the who are on site on the project to be communicating with the back office, so that if there are concerns about payment, those with all of the documents and preparing and submitting payment applications know what's going on. We want some tickers or red flags in your system for what those deadlines are for filing claims in the state where your project is located. One reason for this might be, and in Missouri, we've got a statute that if you're going to file a lien for equipment rental, you have to give notice a lot sooner than if you're a subcontractor performing work. So be aware of those types of requirements and deadlines. Also, notice requirements. So who do you have to give notice to? When do you have to give notice? And how does that relate to the deadline for filing a lien? So in Missouri, I think I've already mentioned you've got 6 months to file a lien, but if you're a subcontractor, you have to give notice of your intention to do so at least 10 days before. So you can't wait till the very last minute, especially if you're going to have trouble getting that notice served on the owners. And then here's my constant plea for good documentation. When it comes time to filing the lien, you're going to need documentation of all of the costs that go into your lien claim: labor, material, and equipment rental. So maintain that, have it ready to go. These types of things will cost you less to prepare, for a lawyer to prepare, or anybody to look at and prepare, than if you walk in their office with a shoebox full of documents, which does happen with smaller contractors. So maintaining your project documentation is key, and having access to it and being able to get that over to whoever's putting together your claim. And then once again, send your notices early. There's no reason to wait to send a notice. Put everybody you can on notice of your situation. And that's the end of the slides for today. I think I've run right up to my time limit here, but I did save 3 minutes apparently for questions. So do we have any questions, Diana?
Leslie, no, we don't have any questions right now.
Okay, great. Well, if questions do come up after watching this, you feel free to email me. My email address is on the screen. Actually, that's my cell phone number, so feel free to give me a call if you've got some questions. We'd also love it if you could take a moment to review us on Google. There is a QR code there on the screen at the moment that you can utilize for that purpose. And then finally, just thank you, and thanks for being a part of our webinar today.
Thank you very much, Leslie, and thank you everyone for your time. Have a sunny day.